Hello, friends. Welcome to my channel. This is your girl Mercy. This is Lawyers Info Hub. This is a channel where I share about law practice, tips for excellent practice, how to navigate through privilege, law practice as a lawyer, practicing in Nigeria, just all that pertains to having a good practice. So today I'm going to talk about how to set aside or quash bench warrants. Sometimes we hear bench warrants, warrants of arrest, and all of that. So today I'm going to give a brief talk on it, and I'm hopeful that you will learn something from it. Bench warrants are usually issued by the court where there's a failure to obey a court order, where a court maybe makes an order and the person to read the order is directed to disobeys, or maybe the group of people who the order is directed that disobeys the court or the order of the court, then the court can issue a bench warrant. Now, also, it can come in a circumstance where someone who is before the court as an accused person or a defendant who is answering the charges against him, and the court can order a bench warrant to arrest that person when the person disobeys the order of court or does not come to court, on a scheduled date. Now, it's also issued where a person is in contempt of court. That is contempt ex facie cubia. This is, for instance, maybe there's an order of court for parties to maintain maybe status quo, or there's an order of court for a party not to do something. And when the party goes ahead to do that, the court can be urged to issue a bench warrant with respect to that thing. No, that disobedience didn't happen in the face of the court, it happened outside the court. The bench warrant can also be issued in that respect. Now, when a bench warrant is issued, it means arrest this person immediately. When it's issued, the warrant of arrest can be effected to arrest that person. Now, all this issue of bench warrant can be seen under Section 184 of the ACJA 2015. You can also look at Section 35 sub 1 and 2 of the ACJA 2, Section 22 of the CPC, Section 22 of the ACJL Lagos, 2011. You can also look at it at Section 70 of the CPC. When a warrant of arrest may be directed to a police officer to effect that bench warrant, or can be addressed to all police officers. Any police officer can just effect it or execute it. Now, it is in force. The warrant of arrest is in force until it is executed, or the judge or the magistrate now cancels it. Now, when it is now used to effect arrest, it cannot be used again to rearrest that person again. Sometimes we've seen situations where the warrant of arrest was used to arrest someone, then much later, the person is rearrested on that same warrant. It ought not to be so. Once the warrant of arrest has been used to give effect to the bench warrant, it cannot be used again to rearrest the same person. No, it cannot be done. It ought not to be. So when things like that happen, you know that something is wrong somewhere. Now, where a bench warrant has been issued by the court, now if the law counsel to the affected person may decide to no, maybe my client disobeyed the order of court for some reasons, or something came up that made him not to be able to attend court or not to be able to obey the order of the court. So the lawyer can make an application asking the court to set aside or quash the said bench warrant. Now, to do that, you have to file a motion on notice. Yes, it has to be on notice because the prosecutor or the state, depending on who is prosecuted, um, or who's on the other side, will have to respond to that. Most times, there's always a counter affidavit filed in response to that motion, urging the court not to set aside bench warrant. But normally you file a motion on notice, praying for an order to set aside the order of bench warrant made on the dash any date 2021 for the arrest of the first accused person or second accused person or third accused person, as the case may be, stroke applicant in this case. Then you have to also put the omnibus ground. Now, where, for instance, let me say this, where there is a bail condition has been revoked, where the bail has been revoked in the instance, peradventure, a bail has been revoked and a bench warrant issued, you know, on the premise that the accused or the defendant didn't show up in court. In bringing an application to quash the bench warrant, you can also add an order asking the court, not to, to set aside this is the revocation of the bail, set aside that order. So, but in this instance, what I'm relying on more, or what I'm focusing on is quashing or setting aside of the bench warrant. So, just an order setting aside the order of bench warrant made on this dash date dash for the arrest of the second applicant or the second accused person or second first accused person, as the case may be, through applicant in this case. Then the omnibus prayer, which is for such further orders that God may seem fit to make in the circumstance. Now, another very important document to add is your supporting affidavit, which should accompany every motion. Now in this your affidavit, this is where you state what really happened, why the applicant failed to obey the order of the court. This is where, peradventure, there is a medical emergency. This is where you state it, that there was a medical emergency maybe 2 days before the court sitting or on the day of the court sitting, which made it impossible for the applicant not to be in court. Now, in stating that, you have to exhibit the medical report. You have to exhibit the medical report, the medical bill, or just the doctor's report to state, this person was admitted, or look at what happened. The person couldn't, was indisposed to attend the court sitting or whatever. Now, there's also instances where coming to court and maybe there's an accident or there was a car issue, there was a flat tire. Those are contingent reasons, made it impossible, or maybe the person later came late. So these are the circumstances you state in your affidavit to tell the court this absence was not to spite the court. This absence was not included disobedience, was just circumstances beyond the person's control. So you have to state it clearly in the affidavit, and also state, peradventure, the person has always ensured that he attends court. There's always consistency in attendance of court. Can also state the court that this person has never missed any of the dates. So that the fact that he missed that day shows that actually something went wrong. Now there could also be an instance where the party was misinformed by counsel. Maybe counsel didn't hear properly the date the court say there was the adjourned date. Maybe told the applicant, you're coming on the 15th, whereby the matter was supposed to come on the 16th or 14th. Now the applicant comes to court maybe on the date that was the wrong date. So these are things you can put in the affidavit to tell the court that this thing that happened, my absence was not out of disrespect, but out of circumstances beyond my control or misrepresentation, as the case may be. Now, the affidavit must be able to appeal to the court, the conscience of the court. State the history of the matter, how we have been consistent in coming to court, state the reason, and if it's an issue of sickness, state it, and to appeal to the conscience of the court, for the court, to set aside or quash that bench warrant. Now, if nothing is done about it, it must be obeyed to the letter, unless the court cancels it, like I said earlier. Now, even if there's a counter affidavit, Even if there's a counter affidavit to that effect, you can also file a reply in point of law. Then you now bring up in your written address, bring up cases that you know are in line with your argument as to when the court can set aside or can quash or set aside bench warrant. So there are a plethora of cases, a lot of cases where the court has set aside a bench warrant. So you look out for them, use it in your final your written address, and I give to your favor in the light that the court has the power and to exercise its discretion in setting aside or quashing the bench warrant so ordered. So by the time now, on the day you're going to move this motion or on the next date, the applicant should be in court.